Chapter 38. Official Misconduct. Section 615. In general, official misconduct which is indictable at common law may consist of malfeasance or nonfeasance. Malfeasance by a public officer consists of the performance of an illegal act, or the abuse of a discretionary power, from an improper motive. Nonfeasance consists in willful neglect by a public officer to perform an official duty which he is legally bound to perform, provided the discharge of such duty does not entail greater danger than a person of ordinary firmness and activity may be expected to encounter. In malfeasance, the illegal act may consist in extortion, oppression, fraud or breach of trust. Extortion consists in taking from a person, under color of office, something of value which is not due. It is separate and distinct from the crime of bribery. Oppression consists in inflicting upon a person bodily injury, imprisonment or other harm not amounting to extortion. Fraud or breach of trust affecting the public, committed by a public officer in the discharge of his official duties, may be indictable although the same act when affecting only a private party would not be indictable. Section 616. Partial, malicious and corrupt acts by magistrates. Where magistrates in the exercise of their official duties act partially, maliciously or corruptly, they are criminally liable. Where a justice of the peace refused a license to a man because of the latter's refusal to vote as the justice desired him to do, he committed a misdemeanor. And where two justices of the peace, whose duty it was to vote for certain candidates for office, entered into a corrupt bargain whereby each agreed to vote for a certain candidate, and the nefarious bargain was carried out, their offense was held indictable at common law. The defendants were justices of the peace, and as such held an office of high trust and confidence. In that character they were called upon to vote for others, for offices, also implying trust and confidence. Their duty required them to vote in reference only to the merit and qualifications of the officers, and yet, upon the pleadings in this case, it appears that they wickedly and corruptly violated their duty, and betrayed the confidence reposed in them, by voting under the influence of a corrupt bargain, or reciprocal promise, by which they had come under a reciprocal obligation to vote respectively for a particular person, no matter how inferior the qualifications to their competitors. It would seem, then, upon these general principles, previously stated, that the offense in the information is indictable at common law. A de facto officer is criminally liable for misfeasance. Section 617. Other misconduct of officials which is indictable. Where a commissary of public stores contracts with a party for supplies on condition that the latter divide with him the profits, the former is criminally liable. And where an accountant in a public office fraudulently omits to make entries in his accounts, whereby the cashier is enabled to retain money and appropriate the interest thereon, the accountant is guilty of a criminal offense. It also has been held that a public officer who gets drunk while engaged in discharging his official duties commits a misdemeanor. Section 618. Refusal to accept public office. At common law it is a misdemeanor for any person unlawfully to refuse or omit to take upon himself and serve in any public office which he is by law required to accept if duly appointed, provided no other penalty is imposed by law for such refusal or neglect, or the law or custom does not permit composition in place of serving. Section 619. Extortion. This, as previously defined, is the taking under color of office, something of value which is not due. It is often considered by text writers as a distinct crime under a separate heading. To be guilty of the offense one must be an officer, and if no such officer is known to the law, as defendant was claimed to be, then he cannot be guilty of extortion. But a de facto officer may commit the offense, or one who after his term has expired, collects illegal fees. The fees must have been exacted by the officer, not paid to him voluntarily, and must have been received in an official capacity. The taking of fees on the ground of extra work is prohibited and such fees are illegal. A corrupt intent was essential at common law, but is not under some statutes. An honest belief the fees were due is no defense. Demanding fees before due is extortion at common law. Threatening prosecution to collect a debt or claim is not extortion.